Good morning. This is Wednesday, December 3rd, 2025, and I will call the ECMC General Meeting to order. First step is a roll call of commissioners.
Thank you. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Ray, Commissioner Robbins. Mr. Chair, you have four commissioners present.
Thank you. And just an acknowledgement that Chair Robbins is not here today. He had an emergent situation and is unable to make the meeting today. Next on the agenda is commissioner comments, and I do have a couple of comments that I'll start with. First, I did want to take a moment and grieve the loss of Senator Faith Winter. Senator Winter was a strong leader who advocated for community, climate, transportation, and families. She was a prime sponsor of Senate Bill 19181, which shifted how oil and gas development was regulated in the state of Colorado and shifted the mission of this agency from one that fosters oil and gas development with consideration for impacts to public health and the environment to one that regulates oil and gas development to ensure protection of public health, welfare, the environment, and wildlife resources. She also provided leadership to ensure the success of this effort by pushing the agency to reimagine itself and its role in Colorado. In addition, she's been a prime sponsor of many other pieces of legislation that reformed transportation and transit, pushed for emissions reductions across the spectrum, and was a strong advocate for clean energy and environmental justice. Her efforts have led to a stronger state government and a better Colorado. I speak, I think, on behalf of myself and all of ECMC in giving our sincere condolences to the family and loved ones she left behind. Her passion, energy, and love for Colorado will certainly be missed. The other thing I think we need to discuss this morning is the fact that because Chair Robbins is not here today, and we had continued the state sunlight long OGDP to this date, and we had all been involved with that up until this point. I think we may want to consider a continuance to December 10th to allow for Chair Robbins to fully participate in the deliberations associated with that. But I open it up to the other commissioners for thoughts on that. Commissioner Ackerman.
Thank you, Commissioner Messner. That makes a lot of sense to me. Historically, when we start something together, we try to finish it together if at all possible. And so it certainly would align with how we generally handle things. And would just have a question to Mr. Thomas. Logistically, does that entail just us reaching out to the parties and assuring that that date works for them?
Mr. Thomas.
Yes, in preparation, we have already reached out to the parties to express this possibility that the commission would be considering something today. So I believe they all are aware that this may be continued at the commission's desire to the 10th.
Thank you. And then Commissioner Messner, I certainly I don't want to cut off discussion, but if there's no further discussion, I would make a motion that we continue to the 10th.
Commissioner Cross.
Thank you, Mr. Chair. I would second that motion. I think it's appropriate, as Commissioner Ackerman stated. I think the fact that Jeff has participated in all of the hearing dates to this point, I think everyone would benefit from his views as well on this matter. So I would be in favor of continuing.
So we have a motion and a second to move both the docket number 241200313 and the associated executive session to December 10th. Is there any further discussion? All those in favor signify by saying aye. Aye.
Aye.
Any opposed? So that docket item then will be moved to December 10th. Anything else we need to do on that, Mr. Thomas or AAG Boudreau?
No, I think that's fine, Mr. Chair.
Okay. So those are my commissioner comments. Is there any other commissioners with comments? Commissioner Ackerman?
Thanks, Mr. Chair. I appreciate it. I just wanted to take a couple of minutes and let folks know that although geothermal work hasn't been on the forefront of the commission's agenda as of recent, other than Mr. Morgan's update recently, we remain heavily engaged in the geothermal discussions within the state and across the nation. This past couple of days, Director Murphy and I and staff members have been at the Payne Institute Geothermal Symposium up at the School of Mines, which brought together a lot of the top thinkers on geothermal and a lot of the movers on geothermal. Had lots of good discussions with a lot of different groups there. We also are engaged in the Colorado Geothermal Council. That's a group that's been put together to continue to further the work of geothermal, particularly in Colorado, but again, to remain engaged throughout the nation and the world. We held a couple of listening sessions during our commission meetings and hearings last week, and so I was unable to attend, but we had staff down in Montrose and Telluride last week. We were out with NREL, who's at this point kind of leading that group. And a side note, NREL just announced that it's now the National Laboratory of the Rockies. The name has been changed officially. And so we're all getting used to that change. But that group is helping to lead our efforts as we continue to talk about geothermal in Colorado and work behind the scenes to continue to further the work that's being done currently and promote work that we certainly can continue to do in the future. So sitting on the Colorado Geothermal Council from ECMC are myself, Director Murphy, and Mike Rigby from staff. So that's the only update that I have at this point. Thanks.
Thanks, Commissioner Ackerman, keeping us in the loop there. Other commissioner comments? Seeing none, we'll move on to consent agenda. Is there any questions about consent agenda? Then I'd entertain a motion for the consent agenda.
So moved.
That's a move in to approve the consent
To
agenda.
approve, yes.
I'll second that motion.
All right, we have a motion and a second. Any further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That motion carries. Next on the agenda is a ECMC hearing presentation by the hearing officer or about the hearing officer review process. So Mr. Thomas, the floor is yours.
Good morning, commissioners. Elias Thomas, ECMC Hearings Manager. Give me one moment to share my screen here. Well, I'm Elias Thomas. Obviously, I'm before you all every week, and I'm here to do a weekly staff presentation or a monthly staff presentation. This time on the hearings unit. Obviously, the hearings unit has two main responsibilities. One of them is running the hearing and running the commission hearings. But the other one is one that isn't seen up front as often, and that's what the hearing officers do on a weekly basis or on a daily basis, which is move cases forward to present to you. And they're working the caseload of all types of hearing applications. So the intent of this presentation is to give you a bit more. Oh, I'm sorry, I'm not in presentation mode. You can still see all my tabs as well, or?
No, it's in presentation mode now. So I think you're good.
Okay, great. Thank you again. So as I was saying, I just wanted to give the commission and the public a bit of an overview of the hearing officer review process, what they do day to day, and how matters get before the commission. All applications do, for the most part, end up before the commission for a final disposition, but how they get there is not always up front and center. So what I wanted to start with is this first chart. This is a breakdown of what we have pending before us currently. Right now, we have a total of about 315 applications, and you can see that breakdown here. However, this is raw data, and there's a couple of caveats that go along with this. One of those being that variances are much more difficult to review because of how site specific and rule specific they are. They take a lot more staff review, which is why that number is a bit higher. Enforcement matters are inherently petitioned. I'm going to get into how the petition process delays, and not delays, but prolongs the life of a hearing application later on in this presentation. And then you might notice what we see most on consent agenda here, pooling and spacing, relatively small percentages of our current docket. However, I would note that every docket proceeds, every application type proceeds on its own unique process. And so those two, if uncontested, can move a lot faster. And then finally, I would note that OGDPs also, nearly all of them entail at least one standalone spacing application, which are not outlined here because those are part of an OGDP application. So to give you a sense of what our actual case flow looks like, here's a second chart of all of the complete applications that you've heard this year. And you can see that breakdown is a little more balanced. We've processed over 220 matters this year before the commission. About 100 of those would be pooling and spacing. On the other hand, enforcement, as you can see, 40 have been completed. So even though those are inherently petition matters, they still move relatively quickly. And the variances, while they take some time, are still being processed at a promising rate too. And I show you this to give you a sense of what the hearing officer's role is behind the scenes in processing uncontested matters and contested matters that ultimately come before you on the two different paths we're going to discuss. So meanwhile, while you all see items on consent agenda, recommended orders on consent agenda, or recommended orders approving administrative orders by consent entered into an enforcement, the pre-hearing process in all of those can be quite extensive and quite different. And so I've put together a very convoluted but simplistic chart for you about the general hearings process. This applies to all applications. All applications are filed and they undergo staff review. The hearing officers review every application and every filing, and every application, with the exception of a couple types, is also reviewed by another unit of staff. So for example, pooling is always reviewed by our permitting staff. Spacing is reviewed by permitting and engineering. And OGDPs are reviewed by both as well as our location assessment specialists. So depending on the complexity of the application and the rules they implicate, there could be a lot of review there. The next step is the notice of hearing. If all of those units sign off for the most part, then the application is deemed complete. It meets the baseline rules for the application, and the hearing officers are the ones that set the first schedule. They issue the notice of hearing that's signed by the secretary, and the parties have to publish that and send that notice along with the application to all interested parties. Interested parties differ from application type to application type as well. It could be as few as a relevant local government and the director of the ECMC. It could be as many as thousands of individual mineral owners that live near a proposed development. So that can be quite extensive. Normally, notice of hearing, we call that the petition period, because one thing the notice of hearing lays out is when petitions to an application must be submitted. Petition periods and the notice of hearing usually run from 60 to 90 days, and the petition period is usually 30 days before the hearing. The lone exception is pooling, and that's due to some changes to the statute that occurred last year. That petition period is 60 days before the hearing. And that step is the key to determining how dockets move forward. As you can see here, if there's no petition, it's a very straightforward and simple process to go to a recommended order. And then most of the time, those appear before the commission on consent agenda or as a presentation of an uncontested OGDP. I want to spend a little more time talking about what happens when we go into a contested hearing process, because there's a bit more nuance and the rules are a bit more detailed about the process that needs to be followed, as well as the information that needs to be provided to complete the record. And there's also a dependency on, as you see up here, Rule 503H, which designates what must go directly before the commission versus what can go before the hearing officer. So the easy path that we first discussed is uncontested matters. If that petition period goes by and we don't have a petitioner, generally those matters can go on consent agenda, i.e. staff reviews have been completed, the hearing officer has reviewed everything that's filed, and we've determined that they've complied with all of the statutory rules for what the application must look like, what's been provided, and that what's been provided actually complies with every rule that needs to be complied with. As you know, this is nothing new. The commission can approve multiple matters with a single vote on the consent agenda, and usually there's something there weekly. And generally, because those are unpetitioned, they don't get challenged. There's no exception process for that because there was no petitioner. So those become final generally 30 days after the commission vote, which is outlined in our process as well. Types of matters you see on consent agenda. We've seen payment of proceeds matters where there's no petitioner, which are somewhat rare, but do happen from time to time. We see a lot of pooling, we see a lot of spacing, and we see very specific types of variances that go on consent agenda. Now, I just want to outline the difference here between what happens if that petition does come in. Right here is a pretty simple pooling application. On the right is one that's uncontested. You see that docket has 14 filings in it. This is one that goes through very quickly, and it gets through our system in 118 days. That's 90 days of the notice period, plus give or take 30 days or so for the staff review period. So that one zoomed by. You see on the left a contested matter, and we have 44 documents in there. And so the hearing officer's job gets much more complicated and in-depth. And we're moving from more of a pure procedural standpoint in moving consent agenda matter through to a full informal legal adjudication type of process. That's the pre-hearing process we're talking about. So you see it goes from 14 to 44 records, and an extra 70 or so days on top of that. Here's something similar for an OGDP that goes through. You can see on the right, that's an OGDP that pretty much flew through our system. There were no issues across the board with it. That's 23 records that go before you, and then an OGDP presentation. On the right, you see a contested OGDP, an extra 100 days and over 300 documents in the record that we need to review. And I just show you this to give you a sense of the variation, the breadth of what we see coming before us. Petitioned matters take on a different posture. And so the commission or the hearing officer's role in those types of matters is not just making sure everything is followed to a T, but now we're dealing with a lot of times novel legal issues presented by petitioners and parties. And we're taking a much more in-depth look at everything that's been filed, in the sense that we need to view those in the purview of what's being argued before us. And again, this is nothing new to all of you. You've done the same thing when contested matters come before you. And this year you've had both of these types of contested matters before you, so you understand what it takes to go through all those materials. So the next step when we get a petition is determining whether the commission or the hearing officer can actually hear the matter. And this greatly affects the hearing officer's posture with how they review the filings and what they're ruling on. Rule 503H outlines certain matters that must go before the commission without exception. Those matters, and I'll show you right here, are listed on the left: caps, setbacks or substantial equivalency, variances, rulemakings, financial assurance, well or location closures. And then OGDPs are not actually listed in Rule 503H, but the commission has issued a standing order stating that they would like to hear those matters. So those cannot be heard by a hearing officer. And so all of those matters go before the commission for final disposition, but that doesn't mean the hearing officer isn't involved in teeing those up for you or dealing with preliminary matters. And so their role changes in terms of what can the hearing officer resolve before this goes before the commission to make sure the commission gets the appropriate record to make their decision. Now you'll see on the right what's not listed. standalone spacing, pooling, unitization, payment of proceeds, enforcement, orphan well applications, petitions for reviews, and then catch-all, general administrative. Just because those are all not listed doesn't mean the commission can't order one of those to come up and be heard by the commission. The commission did that earlier this year when they granted an exception and then asked for a hearing on the merits before them in a pooling application. There's nothing that says the commission can't flag a certain enforcement matter and determine that they would like to hear that matter, for example. And we've also seen parties file requests for removal to the commission that we've had the commission entertain from time to time. However, the general position is that those matters on the right, the hearing officer can hear to completion, and those matters would come before the commission first as a recommended order, which the commission could stay at their pleasure, or following a recommended order as an exception, should one of the parties still wish to be heard by the commission. So the posture here is quite different. On the left-hand side, we're moving those matters to the commission for a hearing, and we're teeing that up the best we can to make sure everything is resolved and to make sure the hearing that can be resolved procedurally before it gets to you, and to make sure that the hearing is organized and ready to be heard expediently. On the right-hand side, those matters, the commission is our review board. And so you serve to conduct the appeals process for most of those, should you disagree with our decision or have that heard as an exception. And those color how the hearing officer is going to decide how to build the structure of the case. So with that in mind, we can go to the contested hearing process here. This governs what the hearing officer can do from time to time. And as you can see, what we try and do with Rule 509, it's pretty laid out. It lays out pretty clearly what the hearing officer has the authority to do and the discretion to do. And so the goals here, we want to prepare the matter for hearing in an organized and formal manner. We want to promote expediency and honor due process. And we want to resolve any preliminary matters. We also want to make sure that the record is complete to the extent needed for either a review or a full commission hearing. And really, this comes down to four big steps that are outlined in Rule 509. The initial pre-hearing conference is the first step. Pre-hearing conferences in our rules are encouraged, not required. However, it's pretty common for us, as you see here, we will conduct at least two pre-hearing conferences, the initial pre-hearing conference and then the final pre-hearing conference. The initial pre-hearing conference is what we do as soon as we can after we receive a petition. It's our first opportunity to get the parties together. Those are always recorded and placed into the record as well. At the initial pre-hearing conference, what we're trying to determine is, okay, what are the issues that have been presented? How many of those issues are relevant? What can we narrow down and deal with? Is there any possibility for a resolution without a hearing that we need to build into our schedule moving forward? And some other issues that the parties may want to raise procedurally. Big issues that come up during pre-hearing conferences more and more often is something like discovery. The baseline is that we don't authorize discovery. However, we get many requests for it. And so in some cases, depending on the type of application and the petition that was filed, we will authorize certain limited discovery. All of this is going to be laid out in what comes out of the initial pre-hearing conference, and that's the case management order. This is the first shot at scheduling the matter on a process for hearing. We're going to set deadlines for every filing we expect to see. Often that entails stipulated facts, as I said, discovery, pre-hearing statements, which more adequately lay out the parties' positions. It's also going to set deadlines for things like, do we have a dispute over affected person status, i.e., can this person actually petition the application? If that's something the petitioner or the hearing officer needs to resolve, which that is something the commission has ordered us to try and resolve in all matters, not just the ones that the hearing officer has authority to do under 503H, if that makes sense. So, for example, and this was before you earlier this year, a contested OGDP with a dispute over affected person status, the hearing officer will issue an order trying to resolve that, which then can be appealed to the commission before the OGDP hearing on the merits. So again, going back to the case management order, that's the first attempt at a schedule. It's going to build in all deadlines, including deadlines for another way that the hearing officer often resolves matters, which is through dispositive motions. Those motions entail basically motions to dismiss or motions for summary judgment based on the record. And this is where our job becomes much more legal. Those are the same type of filings you might see in a court case. Obviously, the administrative sphere is a little more informal than that, but the hearing officers would resolve those, and those matters would end up going before you as a recommended order if one of the parties ends up being dismissed. And so that's another way that this gets prolonged, and that's something the hearing officers spend a lot of time on. We don't, at this point, get a lot of matters that go to a full hearing. Matters are usually resolved in that context, and you see a recommended order down the line. Should we not proceed that way and we move closer and closer to a hearing, then before the hearing date is when we step back in for a final pre-hearing conference. As I said before, there could be multiple pre-hearing conferences in the middle of the initial and final if there's scheduling disputes, discovery disputes, or disputes that arrive over any of the other filings that have come in. But at the final pre-hearing conference, we're hoping that most of those are resolved at the time we're going there, and we're getting ready to tee this up for a hearing either before you or before the hearing officer. Issues that get resolved at the final pre-hearing conference, slightly different since we're down the line a bit more. We're looking more at any leftover discovery disputes, any objections to witnesses or exhibits that have been filed, any questions about process or how a hearing is going to be conducted. And what's born out of that pre-hearing conference is a final pre-hearing order, and that is the skeleton schedule for the hearing. It's going to lay out exactly how the parties are supposed to proceed. It's going to lay out what issues are going to be discussed at the hearing and presented on at the hearing. It's going to lay out every witness and every exhibit and whether those have been admitted or whether objections remain. And it's going to lay out exactly how the parties must proceed at the hearing. Moving forward, as you know, you've seen that pre-hearing order would go to the commission as well, and the commission follows those. Under Rule 509, a pre-hearing order is expected to be considered binding, and we consider those binding on the hearing officer unless there is a good reason to change those. The commission obviously also has the authority to change those as they see fit when a hearing comes before the commission. And that leaves us to the last couple steps that the hearing officers are involved in, and that's the hearing on the merits. Like I said, matters don't get there very often. As is the case with normal court cases, civil cases, most matters do settle. So in the instance where a matter does go to hearing, the hearing officer holds a full hearing, much like the commission would. And they would hold that and end up ultimately coming to a decision. And they would make the same rulings that the commission does in a contested hearing. And what would come out of that is likely a recommended order on the merits. And this would take the form of something like the final commission orders that you often see coming out of commission hearings, where the issues would be resolved and we would be assessing the evidence presented, the credibility of witnesses, et cetera, et cetera. Because that's a recommended order, it still comes before you. But instead of a multi-day hearing before you, it comes first as a recommended order that you can vote or pass on, depending, or you wouldn't vote on it. It would come before you, you can stay it or pass on it. And then could come back before you as an exception. So even though the hearing officer, and I've said this before, even though the hearing officer has the authority to hold the hearing on the merits on those, nothing that goes before the hearing officer does not pass before you that it gets to that point. And that's, as I said, subject to your review. If there's no exception and the commission does not stay the matter, then that's going to become a final order 20 days after issuance. And that's the hearing officer's last step in this process. They're going to be sending the recommended order to the parties as a final order signed by the secretary. And it, again, looks a lot like the order you see. And if there's no exceptions, that's going to be sent And then if the parties on that at that time want to file an exception, we're the ones that would shepherd that before the commission. So we would set the deadlines for exceptions to be filed, and then set those for disposition by the commission. And that usually comes in two steps. One is a disposition on a request for oral argument, which is allowed under our rules, and then a disposition on the exception on the merits. So even up to the very end, we are still shepherding the process under the 500 series rules before you. And that's the ultimate goal of the hearing officer, is to make sure we're following the process laid out, making sure that the record follows, the record complies with the APA, and with our rules. And so this was just a very brief outline of the hearing officer's role, from filing all the way to the end to a final order. I don't have much else for you, but I'm happy to take any questions that you have on our process or anything I mentioned that I didn't spend enough time on. So thank you.
Thank you, Mr. Thomas. That's super helpful, I think, both for commissioners and the public to be able to look under the hood and have a better understanding of both the breadth and detail that the hearing officers go through in order to bring these matters forward. And I think a lot of people just don't understand what happens behind the scenes. And so really appreciate you providing that perspective. And with that, I'll open it up to commissioners for questions. Not seeing a lot of questions, Mr. Thomas. I think a couple of things that I kind of took away from that. I mean, you guys are processing a lot of information and a lot of cases, and none of them are easy, and they all have significant amount of review associated with them, and a lot of attention put on each of those, even if they may move more rapidly through a process or not. They're still getting that necessary review at the different stages. And I think it is important to know that all of this information does come before the commissioners, and we do review all of this information prior to making any determination at hearing, and have the ability to pull anything up to the commission for a determination, most anything. And so it gets the necessary next level of review, even if it's a recommended order or on the consent agenda at the commission level before any final determination is made. And so I think that's an important piece to understand. Yeah, I think that was really good. Really appreciate all the work that you do. I know that it pushes your capacity, I'm sure. But it's really appreciated by us, and certainly acknowledge the amount of work you all do. So thank you for that.
Thank you. We appreciate that. And I guess I'll end by just, of course, reminding the commissioners that any process questions you may have or concerns, please always free to bring them to me, in terms of improving that process and transparency and accessibility of how the hearings unit operates.
Great. Thanks. So with that, next on the agenda, if I can get to the agenda, is docket number 2505000086, which is an oil and gas development plan by Desert Eagle Operating LLC. So Mr. Thomas, if we want to elevate the parties and do whatever swearing in we need to do, that'd be great.
Yes, thank you for your patience. We'll slowly elevate the panel. Mr. McKee, I believe we have everyone on the panel.
I believe that's correct, Mr. Thomas.
Mr. Chair, apologies, I lost internet connection. Are we at the swearing in phase?
You're up.
Great. I'll ask each of the witnesses to be visualized. When I call your name, please raise your hand, state your first and last name, and swear to tell the truth. We'll start with Deidre O'Callahan.
Hi there, my name is Deidre O'Callahan. I do swear to tell the truth.
Apologies if I mess up this name. Graham Bockhart.
Good morning. My name is Graham Borchardt. I swear to tell the truth.
Brad Butler. You're muted, Mr. Butler. Mr. Butler, we'll come back to you at the end. Oh, you got it.
Sorry
Go
about
ahead.
that. Brad Butler, I swear to tell the truth.
Thank you. Wesley Marshall,
Wesley Marshall, I swear to tell the truth.
Kelly Cox,
And I swear to tell the truth. Hello. Good morning.
thank you. Andrew Payton,
Andrew Payton, I swear to tell the truth. Sorry, I'm having some video issues.
okay, thank you. Mr. McKee, did I get all your witnesses?
I believe there's one more, Kathy Bluff.
Wolf.
Go ahead, Ms. Bolf.
Well, Kathy Bulf, I swear to tell the truth, but I don't see me on this.
You're there.
Okay.
I can see you. Thank you. Thank you, Mr. Chair. I believe that's everyone.
Great. Mr. McKee, you can begin when you're ready.
All right, Ms. Aronson, will you bring up the presentation, and everyone else besides Graham can shut off their video for now? All right. Well, good morning, commissioners, ECMC staff, and members of the public. My name is Ryan McKee. I'm a shareholder with Beatty and Wozniak, and with my colleague Laura Aronson, we represent Desert Eagle Energy Operating, LLC, in docket number 250-50086, which is an application for the approval of the Permian Dome State Land Section 16 Oil and Gas Development Plan. The Permian Dome State OGDP is a proposed helium development covering approximately 640 acres that proposes 4 new oil and gas locations with 1 vertical well at each location, all targeting the Lions Formation and potentially the Precambrian crystalline basement. The OGDP proposes to develop state mineral lands covered by a single Colorado State Land Board lease, with 100% of the working interest being owned by Desert Eagle. And as will be discussed further, there is no request to space the development lands, as each well will be drilled on a lease basis in compliance with Rule 401B well location requirements. The Permian Dome State OGDP is located within Los Animas County, which does not regulate oil and gas siting. Los Animas does issue an administrative permit, which requires a 14-day review of the Form 2A information provided to the ECMC. Desert Eagle has been in consultation with Los Animas County's local government designee regarding this project and is currently engaged with the county to complete the administrative process. Desert Eagle's presentation today, along with the evidence in the record, demonstrates that the Permian Dome State OGDP allows for helium development in a manner that avoids, minimizes, and mitigates impacts to the public, environment, and wildlife. A key highlight of the OGDP is the fact that all 4 planned locations are over 1 mile from any RBUs, HOBUs, and childcare or school facilities. The locations are also over 1 mile from any wildlife receptors. And while the OGDP is within a DIC, which covers all of Los Animas County, because the nearest RBU is over 1 mile away, no additional meeting or consultation requirements were triggered. The Permian Dome State OGDP complies with all substantive and procedural requirements of your rules. There are no comments or protests received for the Permian Dome State OGDP, and the director has reviewed all elements of the Permian Dome State OGDP and has recommended approval pursuant to Rule 306B1, finding that the Permian Dome State OGDP complies with all requirements of the ECMC rules and, in the director's judgment, protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Joining me today to present is Graham Borchardt, a regulatory consultant for Desert Eagle. We will also have a panel of subject matter experts to answer your questions following today's presentation. I'll now turn the presentation over to Graham.
Good morning. As Ryan stated, my name is Graham Borchardt, and I'm a regulatory permitting consultant presenting on behalf of Desert Eagle Operating. If we could go to the next slide, please. We understand this commission has interest in learning more about helium development, so I would like to start our presentation with some general information regarding helium exploration and how it differs from the typical oil and gas development you all see. Helium is an inert gas, meaning it is highly unreactive with other elements. The helium Desert Eagle is developing can be reached with relatively shallow vertical wells that require minimal disturbance to drill and do not require large working pad surfaces during the production phase of the well. Wells are drilled with air utilizing the same equipment needed to drill a water well. No drilling fluids are generally necessary, and produced hydrocarbons or water are generally not expected. Helium wells are speculative in nature, as many factors weigh into the viability of the wells being able to go into production, such as helium concentrations, flow rates, and sustained pressures. If a well does go into production, the non-combustible helium is conveyed to a nearby off-location processing unit directly from the wellhead through a network of polyethylene pipeline. Once at the processing unit, the helium is processed, compressed, and loaded onto tube trailers to be transported to market or other facilities for further processing. Although helium pricing is volatile, helium is essential for a variety of industries, including manufacturing, medical, scientific research, and aerospace. I will now discuss the specifics of the Permian Dome State Land Section 16 OGDP. As Ryan previously indicated, the Permian Dome State Land Section 16 OGDP proposes to develop 4 locations with a single vertical helium well on 640 acres of Colorado State Land Board-owned surface and minerals. Desert Eagle has coordinated with and received approval for the 4 locations from the Colorado State Land Board. Desert Eagle owns 100% of the leasehold interest covering the application lands and will develop the application lands on a lease basis pursuant to ECMC Rule 401B. The proposed wells will develop the Lyons Formation and potentially the Precambrian crystalline basement. This OGDP consists of 4 single well locations in a rural area of Los Animas County, currently used as rangeland on a Colorado State Land Board owned parcel. All 4 locations are located within a disproportionately impacted community. However, all locations have been sited over 1 mile from the nearest residential building unit, high occupancy building unit, designated outdoor activity area, school facility, or child care center. The nearest receptor is over 1 mile away, and that residential building unit is owned by the landowner who controls access to the state land board parcel encompassing the OGDP. A surface use agreement has been signed with that landowner. Further, all 4 locations are located over 1 mile from the nearest high priority habitat. This OGDP is within the ozone attainment area. The 4 locations and their associated Rule 315 areas of evaluation were investigated during an on-site assessment that occurred in August and September of 2024. The areas of evaluation that were used were done so in anticipation of the new rulemaking. Findings from the on-site assessment found that the 4 locations were sited in locations that would have minimal adverse impacts to public health, safety, welfare, the environment, and wildlife resources. The assessment of the areas of evaluation found there are no existing residential building units, high occupancy building units, school facilities, child care centers, high priority habitat, public water system intakes, existing or permitted oil and gas facilities, existing or permitted industrial facilities, major transportation corridors, or any other significant potential sources that may contribute to adverse cumulative impacts within the areas of evaluations for the 4 proposed locations. Additionally, the assessment found that there were no immediately downgradient protected surface waters from the 4 locations. Alternative location analysis was determined not to be required during the completeness review due to the findings of the on-site assessment and citing of the locations being not immediately upgradient from field verified waters of the state. The 4 proposed locations will consist of single conventional vertical helium wells on each working pad surface. Each well will have a maximum depth of approximately 1,500 feet and will be drilled with air without the use of hydraulic fracturing or stimulation. One aspect of this OGDP that differs from previous Desert Eagle OGDPs that I would like to address is the proposed compressor on the Permian Dome 1609 working pad surface. One stipulation from the Colorado State Land Board is that all long-term appurtenances associated with these locations were to be located on the working pad surfaces to limit disturbance. Generally, the location, size, and type of compressor for helium production is determined and permitted after each well is drilled and analyzed. However, due to this stipulation by the Colorado State Land Board and after consultation with staff during the director's pre-application meeting, Desert Eagle included a hypothetical compressor on the Permian Dome 1609 working pad surface that it believes will ultimately be necessary for the conveyance of helium from the wellheads to the off-location processing unit. As previously noted, the specific compressor required cannot be determined until the wells are drilled and more data on the sustained pressure of the wells is collected. Once a specific compressor size and type has been finalized, it will be properly permitted with the ECMC. For the purposes of this application, Desert Eagle was instructed by ECMC staff to assess potential impacts associated with the compressor using calculations based on the largest potential compressor or most impactful scenario that would be required, which is the data submitted on the Form 2B. As discussed earlier, the 4 helium wells will have minimal disturbance size as the oil and gas location will disturb less than 1 acre for development of the well. And after interim reclamation, each well will be reduced down to a 0.4 acre working pad surface that will be utilized during the production phase of the well. Access to the wells will utilize an existing access road to the greatest extent possible, and the proposed pipeline will be constructed immediately adjacent to existing and new location roads at the request of the Colorado State Land Board. In total, this OGDP will only disturb approximately 6.17 acres of rangeland for the construction of the 4 oil and gas locations, as well as their associated access roads and pipeline corridors. The wells will be completed in a relatively short time frame, consisting of 1 to 2 days for site preparation, 7 days to drill the well, 3 days to complete the well, and up to 1 week to perform interim reclamation. The Permian Dome 1602, 1608, and 1616 locations will be tankless during production, and the working pad surfaces will only contain the wellhead and a 6-inch buried helium flow line. As discussed, the Permian Dome 1609 working pad surface will contain a compressor to help convey helium to the off-location processing unit, as well as a condensation tank and oil tank to service the compressor. Because hydrocarbons and produced water are not anticipated, the condensation tank is only precautionary. It will also serve to collect any potential condensation, if any, from the compression of the gas stream and the polyethylene flow line. This compressor will be properly permitted with the ECMC once the specific compressor has been determined. Again, the helium will be conveyed to an off-location processing unit where it will be concentrated, compressed, and loaded into tube trailers for transport to market or other facilities for further processing. As previously noted, the locations are located in a disproportionately impacted community. However, all locations are located over 1 mile away from any residential building units, high occupancy building units, designated outdoor activity areas, school facilities, or child care centers. All of Los Angeles County is designated as a disproportionately impacted community. Therefore, this OGDP could not avoid operating within that designation. CDPHE did not deem consultation was warranted for these locations due to the low EnviroScreen 1.0 and 2.0 scores and the distance from the nearest receptor. The need for consultation was waived during the pre-application meeting by a representative of the CDPHE. In regards to stakeholder and local government outreach, Desert Eagle coordinated with the Colorado State Land Board on the siting of the proposed OGDP and its associated locations and has received their approval. No public comments were received and no petitions were filed. CDPHE and CPW both declined consultation, and neither agency provided concerns or comments during the director's pre-application meeting or during the completeness review process. Additionally, Desert Eagle has entered into a surface use agreement with the owner of the land that controls access to the state land board parcel encompassing this OGDP. This landowner also owns the nearest residential building unit located over 1 mile from the locations. The relative local government is Los Angeles County, which does not regulate the siting of the oil and gas location, but does require an application fee, location bonding, and a 14-day administrative review of the approved Form 2A information provided to the ECMC. Desert Eagle is in the process of completing this administrative process with Los Angeles County for the proposed locations. Desert Eagle Operating will employ these best management practices to avoid, minimize, and mitigate potential impacts from the development of these 4 helium wells. Best management practices that will be implemented to avoid, minimize, or mitigate impacts to air include the following: drilling wells with air over a short 7-day period without the use of drilling mud, hydraulic fracturing, proppant, or stimulation. The wells will connect to the proposed helium gas gathering system during production to avoid unnecessary trips to the location to collect the helium. Best management practices that will be implemented to avoid, minimize, or mitigate impacts from traffic will consist of the following: trips to the location for site preparation, well drilling, and interim reclamation will be limited to 38 round trips. Trips to the working pad surfaces during production of the wells will be limited to an estimated 8 round trips per month. Once the compressor is installed, it is anticipated to be inspected daily. Additional BMPs will include maintaining lower speeds from traffic to avoid unnecessary wear and tear on the access road or potential impacts to wildlife. Access roads will be inspected routinely and any damage promptly repaired. Best management practices that will be implemented to avoid, minimize, or mitigate impacts from spills or leaks include the following: placing a synthetic liner under the drill rig, using double-walled fuel tanks on the drilling rig, and fully contained tanks during production on the Permian Dome 1609 working pad surface. All other locations will be tankless during production. The use of fresh water will be minimized to 4,200 gallons per well for dust suppression and casings of the wells. Best management practices that will be utilized to avoid, minimize, and mitigate impacts to soil include the following: minimizing disturbance within the proposed 1 acre oil and gas location during drilling, preserving topsoil for interim and final reclamation, and implementing stormwater controls to protect topsoil stockpiles from mobilizing. Drill cuttings will be captured by a dust containment system during drilling and disposed of at an off-location approved facility. Best management practices to avoid, minimize, and mitigate impacts to wildlife include the following: siting of the wells, access roads, and pipeline corridors outside of mapped high priority habitat, drilling the wells during daylight hours, and having the locations unlit during production. Reduced traffic speed will be enforced as previously stated. Best management practices that will be implemented to avoid, minimize, and mitigate impacts to public welfare include siting locations over 1 mile from the nearest public welfare receptor and minimizing dust by implementing a water mist system during drilling if necessary, and utilizing the dust containment system for capturing dust and drill cuttings. I want to thank you all for your time and attention to our presentation. I will now turn the presentation back over to Ryan McKee.
Thank you, Graham. Next slide. This marks the final slide in Desert Eagle's presentation today and represents an overview of the requested relief for the Permian Dome State OGDP. Additionally, to close the presentation, I wanted to provide a final overview of the proposed Permian Dome State OGDP and some of its key highlights. The Permian Dome State OGDP will allow for helium development of over 640 acres from 4 locations that will require less than 1 new acre of temporary disturbance for each location, with the total interim reclaimed acreage for each location being less than half an acre. Drilling activities will be completed over a short period of time using a water well-sized drill rig that will utilize air instead of drilling fluids to reach a relatively shallow proposed depth for the wells. Desert Eagle has committed to installing pipelines for helium gas takeaway at these locations, and all 4 of the proposed locations have been sited so that each is greater than 1 mile from any RBU, HOBU, or any school or child care centers, and over 1 mile from any wildlife receptors. The 4 locations are all within an attainment area, and as we stated earlier, no petitions were received against the OGDP and no comments were provided by the public. Lastly, as we previously mentioned, pursuant to the director's recommendation, the Permian Dome State OGDP complies with all requirements of the Commission's rules and, in the Director's judgment, protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. We want to thank the staff for its thoughtful technical review of this project and the Director's recommendation for approval. Finally, we want to thank the Commissioners for your attention to today's presentation. And this concludes our presentation, and the panel is now available for your questions. Laura, you can go ahead and bring down the PowerPoint. Thank you.
Thank you, Mr. McKee. Commissioners, are there questions for the applicant? Commissioner Ackerman?
Thank you, and appreciate the presentation. I just have a couple of clarifying questions, and I guess the first one is just my curiosity. And you mentioned, and I appreciate the extra information that you provided. We know a lot about helium wells, but we appreciate continuing to learn more about them. So thank you for providing a little bit more information. You mentioned that helium wells are highly speculative, and in general, you had to work a little bit differently with the state land board than you have otherwise. And you mentioned that you generally wait to see the type of success that the well has. I just wanted to kind of get a feel for what you've found so far as to what percentage of wells drilled in this nature tend to be moved into the production phase.
Thank you for that question, Commissioner. I would direct you to Deidre O'Callaghan to better answer that question.
Good morning, Commissioners. This is Deidre O'Callaghan. We've been drilling at a nearby location on the Red Rocks project. Most of those wells have discovered helium. They are a little bit different sometimes in volume and pressures. In other areas that are similar, and I turn this over to Andrew to discuss, but we have drilled a number of wells in a similar type formation in Arizona where some were actually dry holes, some were producers with different levels of production, helium percentages, and pressures. We hope that we're going to find helium and decent pressure in all these wells.
Thanks, Ms. O'Callahan. I appreciate that response. And so just to kind of further drill down, again, it's tough to put a percentage on it, but if you find helium, that doesn't necessarily mean that they move into production. They have to be found in certain quantities. And so just from a percentage standpoint, you're drilling, I think, 4 wells here. Based on what you found in the past, would you expect all of them to have a quantity of helium that might qualify them for production, or is it truly just speculative and you're dropping holes, just seeing what you find?
I would probably defer to Andrew Payton on that, but I do know that there's very little geologic information out here. There's a historical well that was drilled in the 60s up to the northwest of this location that did indicate that it would have helium in it, but again, we don't know what the pressures will look like. We hope that all 4 of them will be productive. One of the things that's different about helium versus oil and gas is that there is no value at the wellhead for these wells. The helium has to be processed. It's a very low percentage, in most cases anywhere between, in this area, probably 3 and 7% helium, and the rest is carbon dioxide and mostly nitrogen. And it has to be transported to a helium processing plant where it is separated and then processed and compressed into tube trucks, which then take it away to market or to an additional processing facility. For all practical purposes, we probably need to find, at least 4 or 5 wells to justify the expense of building and operating a plant.
Thank you. I appreciate that additional information. That leads into kind of my second question. I could see from the map you had a pipeline system put there. Is that pipeline system just moving it off the state land board property, or is it hooked to a larger system that you have out there?
We don't have anything built out there yet. This system will go from these 4 wells across the adjacent private landowner's land to a helium processing facility that we intend to build about 1.5 miles or 2 miles north of this on the same landowner's surface.
Thank you. Appreciate that clarification. And the last question I had was and I might have misheard that, but I thought in the presentation it was noted that this was inside of an ozone non-attainment area. I think the right thing is that is not inside an ozone non-attainment area. Just wanted to make that clarification.
That's correct.
Great. Thank you so much. Those are my only questions, Mr. Chair.
Other commissioners with questions? Anyone want to make a motion? Commissioner Ackerman?
Thank you, Mr. Chair. I'll note that I didn't see any suggested conditions of approval from staff in the director's recommendation. Appreciate the application and am interested to see how things go there and hopefully add to the database of information as far as helium is concerned in Southern Colorado. I would move for approval of this application.
Second.
A motion and a second. Is there further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Is there any opposed? That motion carries. The application has been approved. Thank you for presenting in front of us.
Thank you.
Thank you.
So with that, and I'll reiterate for those that maybe weren't with us this morning, Chair Robbins was not able to attend today's hearing. He had an emergent situation that did not allow him to be here today. The commission had a discussion and made a determination to continue docket number 241200313, which is the Crestone Peak Resources Oil and Gas Development Plan State Sunlight Long OGDP to December 10th and the associated executive session as well. And so that will not be heard today to ensure that all 5 commissioners who have been participating in the process up until this point have the ability to participate in the deliberative process in determining the outcome of that particular OGDP. And so that has been continued, and we don't have anything else on the agenda. And so seeing that, I'd entertain a motion for adjournment.
So moved.
I'll second that. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? That concludes the hearing today, and we'll see everyone next week. Thanks.